Bob Bennett. I used to be with a small firm called the Department of Justice. I was a federal prosecutor for about 5 years with the U.S. Attorney's Office.
We can barely hear you, Bob.
Yes, you can hear me. I'll just need to speak up a little. And after that, I was with Coca-Cola in Guatemala until they shot our plant manager, and I decided maybe I should come back to Houston. And I've been in Houston ever since. And basically, in the last iteration of my practice, I represent professionals who have licensing issues, doctors, lawyers, Indian chiefs. Indian chiefs even have licensing sometimes. And try to make sure that they don't lose their license. So today we're going to be talking about how you can keep from getting grieved and what you need to do if you are grieved. So I start off with this point, which I was thinking about traffic lawyers and what you do and how you do it. And I think the most important thing I can tell you is that in order to avoid a grievance, you need to have a fee agreement with your client. You need to have a fee agreement with your client. And my understanding is that some of the traffic attorneys don't do that. They show up in court, they represent the person, they get it resolved, and they move on down the road. Which is nice, except if that client files a grievance against you and you don't have a fee agreement, and the first thing that the Office of Chief Disciplinary Counsel is going to ask for is, did you have a fee agreement? So if you don't have a fee agreement, on my site I have a lot of fee agreement forms, and I'm happy to send you one if you want to see one. In addition to that, at the other end, if you want to avoid grievances, send a letter to your client after you finish the work. Now, I have a program called My Case. I think there was a guy out there with another program. There's not anything really unique about My Case other than the fact that it allows you to keep up with your client and the client to keep up with you. Everything you post on My Case is seen by the client. It's very easy to keep track of your emails, of your communication, of your contact with that client if you have a program like that. I would say it's close to almost malpractice if you don't have something like that. And there are various costs. The gentleman who is here, I guess he's already left, he was telling me that his program, which I'm not familiar with, is a lot cheaper than My Case, and I guess I'm going to explore that and find out how much cheaper it is. But that's really a sort of standard program that you, as an attorney who wants to avoid grievances, should really look into. And the other thing about this talk is that I really don't want to do a monologue as much as I would like to have a dialogue with you. So if anybody has any questions at any time about the grievance process or a situation, and one way you can approach this is, there's an attorney down the hall, or I have heard that, and I'm happy to answer those questions. And they're probably worth exactly what I'm getting paid for to be up here on a Saturday afternoon, but that's okay. I'm happy to answer your questions and try to help you in this process. Okay, let me see if I can get this going. The grievance system in the last 5 years has changed, and the biggest change has been the utilization of an investigatory investigatory hearing. You will get a letter that there is a determination that you may have committed professional misconduct, and we've made this preliminary determination. We're going to respond. And once they do respond, let me just start off with, we all know, working? Okay. We all know that you have to respond to that grievance letter. If you don't respond to that grievance letter, that's a grievance. Okay? And so you compound your problems if you don't respond to that letter. In responding to the letter, you can use anything you want to as far as affidavits, expert reports, depositions, documents. You're trying to show that you didn't engage in professional misconduct. And once that response is sent in, the next step, unless it's dismissed, and sometimes it gets dismissed there, it goes to an investigatory hearing. Okay? At the investigatory hearing, it's sort of like a grand jury process in which you can appear by Zoom in front of the investigatory panel, and the panel will want to ask you questions. You can also have witnesses, you can have experts. At the investigatory hearing is the opportunity for you to make your case and show that you didn't engage in professional misconduct. At the end of the investigatory hearing, if the case is not dismissed, then there will be a recommendation. That recommendation can be all the way from being, we want you to be disbarred, up into a grievance referral program, which is like deferred adjudication, which doesn't go on your record and it's not a bad thing. And of course, there's private reprimands, which also don't go on your record. So that's the important part of what has happened with grievance processing now is this investigatory hearing. Okay, let's see if we can get here. Okay. We have a huge state bar. We have very aggressive chief disciplinary counsel. They're in 4 districts. They make their kudos by prosecuting grievances and trying to get it on. So we have a big business here. This is a former member of the Commission of Lawyer Discipline says that every new attorney after 1999 will have at least 2 disciplinary complaints filed against them during their career. Texas has one of the most complicated, expensive systems of handling grievances in the country. We do. In fact, we're the only state in the country that allows you to have a jury trial if a grievance is filed against you. You have the choice that proceeds of either going to an evidentiary hearing or going to a district court. And with the district court, we're the only state that allows you a jury trial. Now, I'm really not too sure whether you would really want to go in front of a jury with somebody being a client and complaining about you. I generally prefer to have those cases tried in front of a court because juries, I think, is not lawyer friendly. I guess that's the best way to put it. Present disciplinary system, we have an inquiry versus complaint. It's investigated by the Office of Chief Disciplinary Counsel. You've been, it goes to the investigatory hearing. You then have the choice of having it heard by either evidentiary hearing or civil district court. That can be appealed to the Board of Disciplinary Appeals or the Supreme Court. And again, you have punishment from dismissal or grievance referral program to disbarment. Okay, this went into effect in 2018. The big deal is this right here, this investigatory hearing, which is the unique part of what has happened with the grievance system. The Committee on Disciplinary Rules was established, and they are the ones that will propose new revisions to the disciplinary rules, and they continue to meet on a not monthly basis, almost every other month. The Office of Chief District Counsel has a process to identify a complaint that is appropriate for settlement or an investigatory hearing. CDC may authorize a settlement at any time in the disciplinary process. So this is another new aspect of the grievance system, is that at any point in the process, you can negotiate with the Office of Chief Disciplinary Counsel and at the time of the investigatory hearing, and prior to that, to see if there's a settlement that can be reached. Technically, they are engaged in mediation, but I've not had much success with them mediating the case. They always come back and say, well, the commission is already going to do this, nothing more. Statutory standards. So this is one of the big deals. One of the complaints was that out in Big Bend or Amarillo or East Texas, the committees were giving one rule and not giving another, and so they tried to standardize what all the different districts are doing. We also have, this is kind of an interesting thing that I have a real problem with the state bar creating, and that is we now have an ombudsman. That's a woman who's an attorney in the state bar office there in Austin, and her job is to review grievances, receive complaints, receive investigative complaints, answer questions from the public, and assist members of the public wishing to submit a lawyer grievance. We're paid through our bar dues to have this ombudsman there to basically help our clients prosecute us. Now, I'm not exactly happy about that, but I haven't got any of the directors to really do anything about it yet. At one time we had a number of barricade cases in Harris County, and I've not seen any of those more recently, but the Chief District Counsel's office also has the ability to work with the district attorney or with other law enforcement to pursue barricade if they think that's occurred. There is a requirement that the CDC develop guidelines for procedure to report itself. If you committed a criminal offense and are convicted, you need to report that. Of course, if you're convicted of a criminal offense and lose your license, you probably don't care whether you report it or not, but that's the rule. There's also now the CDC, the Research and National Law Regulatory Data Bank, maintained by the American Bar Association, to identify members of the state bar who's listed in another state. So we've gone statewide or nationwide, and if you get a grievance, that would be picked up by this National Law Regulatory Data Bank. The online profile, this is a new rule too. The full text of any type of disciplinary judgment made by a district grievance committee or district judge needs to be on your profile. Let's see, new selection guidelines. Yeah, the question, go ahead and ask us.
Okay. Is it not the bar itself that establishes what limits there are and so forth? We don't have any say in that. As far as I know, there's no questions they ask you about it when you're making up your profile. So how would that work?
How would it work that you need to put on your profile if there's been a sanction?
Yeah, since there's no questions about it, there's no link or nothing in it.
I have not seen that become a grievance for someone failing to do that. Okay? So I've not seen that happen. And it's sort of I wouldn't say a hypothetical rule, but a rule that requires you to do that, but I don't think it's really enforced. That's probably the best answer I can give you on there. Okay, so this CDC, an investigatory hearing, they can do that now, and I've had several of these by Zoom, which is a nice way of doing it, and it saves a lot of travel and a lot of aggravation. So that was a good thing. These subpoenas, I'm not involved in a case right now in which all of the trust account and the operating account have been subpoenaed, and they have to be provided, these documents have to be provided to make sure that you are handling your trust account appropriately. Let me also say that technically, anytime, and again, I've done enough traffic tickets, or been around traffic ticket attorneys to know that sometimes you set a flat fee. Technically, that flat fee at the time you set it has to be placed into the trust account and moved over from the trust account at the time you finish the work. There are some issues that can be finagled as to a flat fee, but I think the better process, and my recommendation, is to put that fee into your trust account, and then once you've done the work, move that over to your operating account. If the Office of Chief District Counsel starts looking into it and sees that you haven't done that, that can be the basis of a grievance of misusing your trust account.
Is there a reference for that, just for information, so we're going I want to
There's
show
a
what my
reference
voice.
to that. I will have to get back to you on that to give you a specific rule, okay? But,
It's in the canons and the footnote as well.
I'm sorry?
It's in the canons and in the footnote as well. It's not, there's no number.
Yes, sir.
Some attorneys used to claim that by putting in a contract, the fee is earned as soon as we get the case and mail the letter of rep, but I guess you're going to indicate that's not true.
No, I mean, there are certain ways of doing a flat fee, okay? I wrote this down. In the written contract, you need to have the scope of representation, how billing or fee is to be handled, check for conflicts, and necessity of confidentiality. These are the best and highest elements that you can have in your fee agreement. Again, what your scope of representation is, how billing or the fee is to be paid or handled, check for conflicts and necessity for confidentiality. Now, I'm putting these things out here because this is what a grievance committee, what the OCDC will be looking for. The fee needs to be understood by the client. The fee needs to be understood by the client. And in writing, the attorney, the client approves of that fee. Okay? I know that language is a little bit awkward, but I'm trying to give you what is the best way to make sure that you're not grieved when the client comes back and says, they're going to charge me $500 for this traffic ticket. He ended up charging me $1,000. I paid that. He won't give it back. He won't give my file back. You want to make it really enhanced. And the next thing you do is you're going to be in front of an investigatory hearing and try to explain why you shouldn't be held as committing professional misconduct. Obviously, all fees need to be reasonable. I mean, there's a sort of a standard fee that the industry charges depending on what type of traffic ticket it is. If you're charging, $10,000 for a parking ticket, and the person pays that and then finds out that, $10,000 was a little bit high, that could be a grievance and an excessive fee. Okay. I want to go into exactly what happens in an evidentiary hearing. The importance of an evidentiary hearing. Now, again, you have gone past the letter, you responded, you've had the investigatory hearing, and now they decided yes, even though you had some good reasons in the investigatory hearing to explain what happened, you still think there's a grievance, and so you get a letter saying you need to select either an evidentiary hearing or a district court. So let me go roundabout again on this to make sure you understand the process. Complaints filed, you get a letter, ask you to respond, investigatory hearing, go through the investigatory hearing, the grievance is still good, and then they send you a letter saying you need to decide whether you want to have an evidentiary hearing or a civil district court. The big deal about an evidentiary hearing is that is the only process that allows you to get a private reprimand. If you go to a civil district court and try this in front of a judge or try it in front of a jury, you don't get a private reprimand. So that's why most of the findings, most of the decisions you see dealing with grievances are in the evidentiary hearing and not in the civil jury trial. The, I guess, advantage to the civil jury trial, either judge or jury, is that the civil rules of procedure and evidence apply, which they don't really apply as extensively or as fully in the evidentiary hearing, is that if you have, for instance, a good motion for summary judgment, you think that you can get rid of the case that way, that would probably be better to go to the civil jury trial process. Let's go about some of the violations here. Sanctions by top areas of law, criminal, civil, and family. Family, obviously, because nobody's happy. Nobody's happy. So you did something wrong, they didn't get the grandfather clock, there's an issue of child support, and so the grievance is filed under family law. Civil cases, criminal cases, immigration is usually the least amount. Like misconduct, obviously you see the communication. Let me go back again. There's nothing better than to have a program like my case or another program like that to be able to show every email, every communication, every document, and as you're doing that, you're informing the client. The client can come on that site, can come on the My Case site and see exactly what you're doing. You have all your emails, you have all your communication, you have everything there, and that can obviously be put together very quickly when you have to respond to a grievance. Communication, this is one of the things. Lawyers should be client reasonably informed about status and have public without reasonable request for information. Okay, so you have a fiduciary duty, obviously, to your client, and it's your responsibility to make sure that the client understands what you're telling them, and to make sure that they have that, and that's a problem. 803, reporting professional misconduct. I always get this question about what happens if I know somebody did something. I have seen maybe, I've been practicing a long time, and I have seen maybe one violation that's come across of failure to report a professional misconduct. I mean, there's a huge level of intent, there's a huge level of knowledge, and generally that doesn't come about as a grievance. Here is neglect, though. Competent and diligent representation. A lawyer should not neglect a legal matter entrusted to a lawyer, frequently fail to carry out legal obligations, most of clients. Neglect signifies inattentiveness involving conscious disregard of responsibilities to a client and clients. There are some clients that I really don't like. I mean, they come to me and they're jerks and they demand this and they demand that. And I really don't like them, okay? Regardless of that, I have a fiduciary duty to them to either say, I'm just not going to take your case, or we've got to the point where I think you need to find another attorney, and then there's ways that you have to deconnect yourself from that client. But it's important for you to be attentive and not, and regard all your responsibilities to that client, okay? The client attorney representation. You get called on the phone, and the person tells you this, and you say, well, I really don't think I can handle that case. Good luck to you. Well, technically, that client who has formed a technical attorney-client relationship with you, simply by that phone call, that can end up as a grievance, especially if you simply don't tell them to go see another attorney, or I don't have anything to do with this, or I can't handle it, and you don't really tell them that there may be a statute of limitations. I'm talking about now the extreme, and I'm also talking about what is the best and highest procedure for you to address that type of problem. It's always better to make a note, always better to say, I talked to James Brown, and I told him these things, and have that either in your software package, in your notes, or in some other way that you can retrieve it, okay? Safeguarding property, this is the trust account. The bar goes crazy over allegation that somebody misused the trust account, didn't pay somebody what they were owed, didn't keep the money in the trust account itself, in the IOTA account, and didn't keep the client informed about what the charges were, or didn't tell the client how much this is going to cost. Conflicts, you have a responsibility as part of your entering into a relationship with a client to find out whether there's conflicts or not. And if you don't have that in your fee agreement, that you checked conflicts and were told by the client that there were none, and what you did to do that, we checked our database, we checked the fact that I thought that Smith had a common name, so I checked on that. So if you want to be sure that you're grievance proof, then make sure you go into, if there's any questions about conflicts. I talked a little bit about this fee issue. Obviously, PI or contingency fee has to be in writing. It can't be a unconscionable fee. And again, this rarely comes up because I think the bar generally and attorneys generally know what the industry charges and they try to, and they know the clients to check on them, and so they try to keep their fees in a reasonable manner. Division of the fee, the issue of making a referral of the fee can be done, but the rule on that is that you have to, if you're going to get a referral from sending a case to somebody else, you have to make sure that the client knows about that. You can't refer a case and try to get 20, 25%, or whatever percentage you have in the referral of that case without the client knowing about that. And most clients don't care, okay? They say, well, is that coming out of my part? No, it's coming out of my part, so don't worry about it. But that has to be in writing and has to be approved by the client. Advertising and solicitation, the Texas Bar, the Advertising Review Committee, is if you haven't dealt with them on any of your marketing and advertising, they are really good about giving you information about your proposed marketing, your website, you send out a newsletter, that kind of thing. And I think you can submit that to the State Bar Advertising Review Committee. I think it's maybe $50 or now $100. They will review that and let you know whether that's keeping with the bar rules. And that's a really good thing to do, depending on how extensive you advertise or market. policy, the advertisement cannot be false, misleading, or deceptive. Only 1% of the violations deal with violations of candor for the tribunal judge. I will say, though, that there is a special emphasis placed by the Office of Chief Disciplinary Counsel if the referral comes from a judge. They really respond to those, and you're going to have, if you get a grievance from a judge, you're going to have to respond, and you're going to have to be sure you do everything right to get that off. Non-client relationships, these are violations dealing with deceptive statements to others, communication unrepresented by counsel. Obviously, if you know somebody represented by counsel, you can't contact that person. You can obviously contact the attorney that represents them. If you're dealing with unrepresented persons, you can't really try to overreach. You can't try to get them to do something illegal, immoral, unethical, etc. Okay, so this is 2122, a grievance is filed. Obviously, most of those ended up in evidentiary hearings, 400 sanctions, disbarment, suspension, private reprimands, 99 went through the grievance referral program, which is a good program if you get it. Okay, so the Safeguard Texas has an ethics helpline. Two attorneys are always on duty with the ethics helpline. You cannot get a written opinion from them. You can't call them up and say, will you send me an email stating what I need to know. You can, however, take down notes that I talked to the Safeguard Texas Ethics Helpline, and they told me these things, and I've been in a situation, even though they don't respond, sent them back an email saying, you said these things to me, and I am relying on what you said. So you have that in your file. The written ethics opinions that you know about, the advertising rules, keep your client files, minimum 5 years. Again, I keep repeating this, but a program like my case or the other case the guy was talking about, other program is a great way of doing that. I have everything on my computer, and both cell phone logs, client logs, and written records are all on my case. Okay? Protections for attorneys, keep your client fully informed. You have the responsibility to do that. Return all forms of false property. Do not engage in sanctions client. Technically, it's not a violation. It can be held in opinion appropriate. There is most bar associations. I know in Harris County, I know in San Antonio, I know in Dallas Fort Worth have fee dispute resolution committees. That's a great way. I actually put that in my contract that they agree to arbitrate that fee if they concept of what the fee should be. That can be mediated to the local bar committee. Your staff can know about this. Resources such as you said, related. Okay, handling grievance. Okay, so again, we talked about the need for a response. Now, I'm going to switch now, talk about the grievances. I want to talk about TLEs, Texas Lawyers Assistance Program. We have some information out there on the table for you. I'm on the committee. We have a trained staff in Austin that you can call 24/7. If you know somebody that has a drinking problem, an addiction problem, a suicidal problem, all those can be handled by a professional staff, confidential, completely confidential, with TLAP in Austin. These are the issues that attorneys have. Suicide is one of the highest causes of death among attorneys, more so than almost any other profession. You get practicing law is not easy. It's not easy. I've been a federal prosecutor, I've been a defense attorney, I've been corporate counsel. I have this kind of little unique practice right now going on. And I'm still very demanding. That you get a situation where you have present criminal defendants, you have the trauma of seeing the client lose a matter, you yourself feel bad about that. And those are the issues that happen. These are the problems that we encounter that you don't need to handle by yourself. You don't need to handle this by yourself. You can always go to various groups. There's lawyers concerned with lawyers, there's CLEs, there's other organizations, AA, etc., that you can connect to. CLEs provides confidential support for licensed professionals, local group support and resources, one-to-one local peer support, self-care, CLE, and service opportunities. This is the Texas Lawyers Assistance Program, or was when I first put this together. Chris Ritter, who's I just love, is now in the General Counsel's office. Eric Grigg, who was the chief, took Chris's place, is now in private practice. And but we have Paul Jacobs and Michelle Lamont, who are now with this, and Penny's still there. Take it seriously. Okay, resource for ethics. I told you about the ethics hotline. There's the Texas Center for Legal Ethics, which is a great source. University of Houston Law Center has Texas Ethics Reporter. State Bar and Cornell University has an excellent source of information on ethics. Grievance and serious matters should try to do a lot of dollars. I'm not going to I really want to go see the airplanes. So, questions. Yes, sir.
Mr. Bennett, can you speak to the validity of a non-refundable retainer agreement?
The bar doesn't like that. Okay, so the bar doesn't like that. You can put together with the knowledge of the client, and one way to do that is by doing it by segments. In other words, I will charge you $1,000 to be in court. I will charge you another $1,000 if it goes to trial. I'll charge you another amount negotiated if you it takes an appeal. So that type of stair-stepping appears to be a reasonable way to do it, okay? But you'll need something like that, and you have to keep in mind that the bar doesn't like it. Okay.
Bob, you said something about needing to keep the client's files for 5 years. A former member of the, longtime member of the grievance committee and state bar president told me that there is no such thing as a time limit as long as you have a reasonable time stated in your contract, and that's what I do. Am I way off base or what?
What do you mean by reasonable time?
What 30 days from the day of the final action? It's in the contract that's final upon it. Keep it for 30 days, but after that, maybe cost me money to keep some things. Nobody's ever asked for their file ever in 4 years.
Okay, the highest and the best is to keep the file. The highest and the best is to keep the file, okay?